welcome to OJN's Legal Peppersoup Podcast. We put the Peppersoup in the podcast because in each episode, we dish up and serve you extra hot legal topics for your consideration and consumption. Our aim is to dissect the issues, get straight to the point, and provide you with useful legal information and advice.
Is that crystal clear like the biblical teke mene you fasting?
We like to keep it simple. Welcome to the show. We're shooting in a slightly different format. This is episode 5. The aim of the program remains the same. That is to dish up and serve extra hot pieces of legal news, information and advice. My name is Obi Wokeji. I'm a solicitor advocate. I've been practicing in the UK since 2003, having previously qualified as a barrister and solicitor in the Supreme Court of Nigeria in 1996. However, do not delay taking legal advice, do not disregard legal advice, do not commence or discontinue any legal action that you have because of anything you've heard on this show. If you have any specific questions, please send them to info@ojnsolicitors.com. In the studio with me today, I have Lawrence Jegede. He's a qualified solicitor. He specializes in civil litigation, employment and immigration law. And I also have Applcn No of Augustus Chambers, who specializes in criminal appeals, human rights law and immigration law. Thank you both for coming.
Thank you.
Now, immigration law is one of the most dynamic areas of law in the UK today, if not the most dynamic area of law. It's constantly changing. There are new laws, there are changes to those laws, updates to the changes, amendments to the changes. There are Court of Appeal cases, Supreme Court cases that are outstanding, which have bearing as to how the current rules are being interpreted by the Home Office. And that's not adding the effects of what Brexit will have on the UK. Now, Lawrence, what are your thoughts in relation to the Immigration Act 2014 and 16? What are the provisions that strike out to you or stand out to you?
What is being termed as right to rent. What that basically means is, before 2014, anybody, as long as you're a resident in the UK, you can approach a landlord, you can approach an estate agent and say, I want to rent your property, and then they will just give it to you. Of course, they can run their own checks, but there is no legal obligation on them as to what to do or not to do. But as a result of 2014 Act, there is now a legal obligation on landlords and estate agents to ensure that any prospective tenant has leave to remain in the UK before they rent out their property to them. And in the event of giving a property to someone that's not lawfully resident in the UK, the landlord or even the estate agent stand the risk of being fined or even being prosecuted. So what you now have is a situation whereby the Home Office has now delegated immigration law enforcement to some sections of the public, for example, the landlords and the estate agent, telling them to ensure that people are lawful in the UK. If they are not, don't give them property.
Doesn't this open the floodgates for discrimination or potential discrimination cases? I mean, Amaka, what are your thoughts in relation to that?
Well, I have many concerns about this, the onus now that's being put on landlords. I mean, it's very similar to employers and how they have to make sure that the person they're employing is legally resident in the United Kingdom. Clearly, it's discriminatory to say to somebody, well, we're not sure about your status, so therefore we're not going to give you a property, particularly when you have people that have children.
What would you advise somebody to do if they are facing a potential eviction or termination of employment because of the way the employer or the landlord is interpreting the Immigration Act? I mean, what can they do? Is there anything that they can do?
You might be able to take legal action against the employer. Some people have done it, some people won, some people lost. The question is, was the employer reasonable in taking the kind of action that it took?
I presume the same would then be if that's for landlords as well.
Landlords, yeah.
So landlords have to be very, very careful. It's amazing how the Home Office have made employers and landlords extended immigration border officials with criminal sanctions to face if they are found to fall foul of the rules. In the Acts now, the Home Office can decide to deprive somebody of their citizenship. And we're seeing that happen now with the Rotherham sex gang. I think there's a case now called Ahmed and Others, 2017 Supper Tribunal case that was heard in February, in which their appeals were dismissed. So they're relying on the actual deprivation of citizenship has been brought into place. initially I thought it would apply to people who already had dual nationality, but from my understanding now is the Home Office just have to show that you'll be able to get citizenship in another country.
Different country, yeah.
Because can you what are your thoughts on Ahmed and others 2017?
Yeah, I mean, just like he rightly said, the Home Office has always been able to deprive someone of their British citizenship, and of course that was anyone could also give up their British citizenship if they so wish to do so. But the threshold for deprivation has always been very, very high. You have to do something really bad before the Home Office could turn around and say we want to take your citizenship away. But the threshold is now been lowered. Before, if your citizenship is taken away from you, or it could only be taken away from you if you have something else to hold on to. For example, just gonna use a random example here. This Jamaican guy who was also a British citizen. Then they could take your British citizenship away from you. Why? Because you have something else left, your Jamaican nationality. The old rationale before was you shouldn't be rendered stateless. But the law is being simplified, or not simplified actually, the law has been made harder now. So, you might not have something else to fall back on, but as long as we are satisfied that you could take up another citizenship, right? If you could still adopt another citizenship of another country, it's now up to you whether you take up that citizenship or not. But we think that, you could go to another country and get your citizenship. Why? Because you were born there. Why? Because your parents came from that country. Why? Because we believe that you should be entitled to that citizenship. Then we're going to take British citizenship from you. The rules of the game have clearly changed. So everybody's finding themselves to you either abide with these new rules, or you face the serious and harsh consequences. So yes, it is not possible to deprive people of their British citizenship, even though they did not have another citizenship at that particular moment.
What do you think about this, Amaka?
I think it's going to come up more and more often because of the terrorism legislation, or those suspected of being involved with terrorism, those going off to fight in different countries, or allegedly training in different countries. And then those who are convicted of very serious offences, I think the Home Office will start to conduct these, deprivation procedures, and it's up to each, or in order to challenge it, you'd have to raise whatever factors are relevant. So birth in the United Kingdom, being born here, what family ties you have, all those things will be important.
Well, I'd like to think they'll only bring them in for the most serious type of cases. For example, this Rotherham sex gang case. I don't think there's anybody that would disagree with that. Mm-hmm. But we just have to be a bit careful as to how the Home Office will choose. I'm not sure what directions there are in as to what kind of cases they will choose or select to deprive a person of his British citizenship. Now, obviously, the Rotherham sex gang case is quite serious. It's quite serious, but we just have to watch out and see whether this will suddenly start going down into cases that are not so serious. I mean, criminal convictions are serious, but I think it's something that has to be watched quite carefully. I mean, but the moral of the story is, don't commit serious crimes. If you do, even if you're a British citizen, we will take it from you.
Absolutely.
I can envisage it being used in cases of murder, even in joint enterprise cases where you have young people allegedly being involved with gangs, and a murder is committed. They may say, well, you've been born here, but you're from a different country, or you have descent from a different country, and therefore you're entitled to the nationality of that different country. So I can actually see, as you say, the threshold being lowered even further. But with the Rotherham case, I think that's a case that's going to be going on for a while. I don't think that it's going to end at the upper tribunal.
No, they'll probably,
I have a feeling it's going to go up to the Supreme Court. And I think the Supreme Court, and I can't, none of us can predict what they will do, because they are the highest judges of the land, and they tend to make decisions or judgments that are sometimes controversial but shocking as well. But I think they will find in this particular case that it was warranted, and deprivation was the right approach by the Secretary of State. It will definitely be the popular finding, so I think that's how it's going to end up. With Article 3 medical cases, the threshold for engagement of Article 3 was very high. You had to show that you were in imminent risk of dying, and if you were returned to your country, essentially you would die. And that's the only way you could seek the benefit of Article 3, which is that you can't be removed to your country if you're going to face inhuman or degrading treatment or torture. When you have a medical case, it's usually that if you go to your country, you would face inhuman or degrading treatment. So you wouldn't receive proper health care, you wouldn't have any supportive network in your country, and therefore your rights under Article 3 would be breached. And that's always been the argument. Prior to this judgment, the main cases dealing with Article 3 and medical care or health concerns was D and the United Kingdom, and N in the United Kingdom. And N was particularly, I would say, unhelpful, because it said essentially that unless you were dying, you weren't going to be able to argue that Article 3 was engaged in your case. Now, in this judgment, the court, first of all, criticised the Belgian authorities very strongly about the way in which they looked at Mr. Paposhvili's case. That is, they didn't really properly assess the medical evidence that he was providing. They didn't really approach his case appropriately. So they did criticise the Belgian authorities' approach and actions. This judgment has been applauded by lawyers in particular, who are happy that the courts have finally realised that even if a person isn't necessarily dying, they could be critically ill, and they would suffer degrading or inhuman treatment if they were returned to their country in cases where they don't have access to proper medical care, or they don't have a supportive network, so they'd be unwell, but on their own they wouldn't have any assistance. So I suppose that's why this case is very important, and it's being argued at the moment.
My experience has been that any application you make under Article 3, the Home Office simply wipe that aside, and they quote the N versus UK case saying that unless you're dying, you can't succeed. So, but surely this can be used for example, we have situations where we have elderly clients who have numerous illnesses. They're being looked after by their children here, even though they're not facing the imminent risk of dying. If they move, at least they can put forward their medical conditions now, and hopefully, probably, can still quote Paposhvili versus Belgium.
Well, I would say be careful what cases or how you argue the point. I don't think you should just argue it because somebody's elderly and has a number of health concerns. I think you have to show that the person is critically unwell, because what you don't want is to put forward cases where the courts will easily say, well, you're misusing the Paposhvili principle.
So it still has to be serious.
So you still have to be careful, I think, with the kinds of cases you're presenting or relying on Paposhvili. That would be my view anyway.
Have you had any Article 3 cases that have succeeded?
Well, in the past, yes.
Article 3?
In the past,
yes.
And when I say in the past, very long time ago.
Yeah.
Recently, not really.
Because
the threshold was raised really, really high, and they made it almost impossible for anybody to satisfy that threshold requirement. But just a thought on this case, I think what is made possible, or what should make possible for people is, in most cases, people really do have that serious medical condition. What Home Office would then normally say is, oh yeah, the medical treatment for that condition is available in your country. As far as they are satisfied that there is available medical treatment in your country, they don't care about accessibility. So what this case, I believe, is done is to say, okay, yes, it might be available, but is it accessible? Can this person access it? That you still have to consider, for example, the financial capacity of this person. It's not enough to say, yes, you can go back to your country and they have that medical treatment. No, you have to consider, is it good enough? Yes, there is a case law that says, yes, we cannot treat the whole world, but I think what this case is done is to bring back some common sense to how Article 3 is being applied in UK courts, and especially by the Home Office. So it's not just it's available, you now need to consider affordability, accessibility as well. So a lot of factors that have been disregarded by the Home Office. If Home Office should pay proper attention to the rationale of this case, that means those factors should now be reintroduced and be applied properly.
Okay, brilliant. Thanks for explaining that case for us. To give you some updates, the Home Office have suspended FLR and set applications following the case of Lebanon and others 2017. So from the 22nd of February, the Home Office have suspended these cases until they decide how they will deal with the financial requirements aspects of family cases, if I'm right. Yes. Also, on 1st of December, something that went under the radar was the change of overstaying, going from 28 days to 14 days, and you still have to provide an explanation as to why you had overstayed. Previously, you could make an application within 28 days of your visa expiring, and that was it. As long as it was within 28 days, the Home Office would consider it. Now you only have 14 days, and you have to provide reasons as to why you couldn't submit your application before your visa expired. And also, good news as always, every April brings cheer. The Home Office have announced increases in their fees, which will be effective from the 6th of April this year. The highlights of this are an application for indefinite leave to remain will now cost £2,297. Yes, you heard that right. I said £2,297. And an application for limited leave to remain, an FLR application, for example, will now cost £993. So again, it's another example of the Home Office crackdown on immigration. I don't know how people are expected to pay this. I did a rough calculation this morning. If it's a family of 5 who are applying for indefinite leave to remain, they have to pay just under £11,500. Where they're going to get this money, I don't know.
It's a case of damned if you do, damned if you don't, because really you're advising people, please come forward to the Home Office and make an application. But when you do make the application, you will be charged a hefty fee. But it has to be done,
I mean, £993 for an FLR application. That's why not just say it's £1,000? I mean, £7 short of the £1,000. All right, so that's it from the Legal Peppersoup podcast. Thank you all for listening, because without you, the viewer and listener now, there is no podcast. Please drop us a comment if you like the show, if you would like us to discuss anything in particular in future episodes. You can contact us on info@ojnsolicitors.com. You can find us on Facebook at I think it's, you just search Facebook, and no, you just use the search term Legal Peppersoup. You can search us on Twitter, and if you have any specific inquiries, please ring the numbers that you'll see on the screen. Thank you very much indeed for taking your time to watch this, and we hope to see you in our next episode.